Good morning. The Committee on General Government Operations, Federal, Foreign, and Regional Affairs now convenes this hearing. For the record, today is September 14, 2017. The time is now 10:30 in the morning. In accordance with the Open Government Law, public notices for today's proceedings were provided to senators, stakeholders, and our local media. A 5-day notice was provided on Wednesday, September 7, 2017, and a 48-hour notice was provided on Monday, September 11, 2017. The public notice was also published in the Pacific Daily News and the Guam Daily Post and the Guam Legislature website. Today, the committee will be hearing and accepting testimony, both oral and written, on the following items. Bill number 92-34 COR is corrected by the prime sponsor, introduced by Senator Mary Camacho Torres. An act to amend subsection 1105 of Chapter 1, Title 2, and amend subsection 5101 of Chapter 5, Title 3, and amend section 6102 of Chapter 6, Title 3, and amend section 15108 of Chapter 15, Title 13, all of Guam Code annotated, relative to extending the legislative term from 2 years to 4 years, prescribing term limits for senators, and establishing the corresponding election cycle for the Guam Legislature. We also have on the agenda Bill number 156-34 COR, introduced by Senator Mary Camacho Torres, an act to amend sections 15201 and sections 15206, both of Article 2, Chapter 15, Title 3, Guam Code annotated, relative to changing the date of the primary election and the date of filing candidate nomination papers. We have on the agenda Bill number 158-34 COR, introduced by Senator Mary Camacho Torres, an act to repeal and reenact Section 3108 and to amend Section 3202, both of Chapter 3, Title 19, Guam Code annotated, relative to names on marriage licenses. We have on the agenda Bill number 163-34 LS, introduced by Senator Joe San Augustine, an act to modify requirements to become a candidate for office and to make Election Day a Government of Guam holiday, to amend Section 6110 of Chapter 6, Title 3, relative to screening candidates in District Court and Guam Department of Revenue and Taxation, to amend Sections 5101A and B of Chapter 5, Title 4, relative to prohibiting unclassified and temporary employees of the government from being eligible to be candidates, to amend Sections 4108 of Chapter 40, Title 5, relative to increasing village residency requirements for mayor and vice mayor candidates, all of the Guam Code annotated, and all relative to requirements, eligibility, and prohibition on being a candidate for office, to add a new Section 1000A8 to Chapter 10 of Title 1, Guam Code annotated, and to renumber the subsequent sections of Sections 1000A accordingly, relative to making Election Day a Government of Guam holiday. I'd like to take a moment to acknowledge the senators who have joined us at this hearing today. To my immediate right is the Vice Chair of the Committee, Senator Mary Camacho Torres, and to my immediate left is Senator Joe San Augustine. Thank you, senators, for being present. We will start off with the first item on the agenda, which is Bill number 92-34, as corrected by the prime sponsor. And I would now like to yield to the author, Senator Mary Camacho Torres, for her opening statement. Senator Torres.
Thank you, Mr. Chairman, and good morning, everybody. Half a day. Bill number 92-34 is an act to amend certain sections of Title 3 Guam Code annotated relative to extending the legislative terms from 2 to 4 years, to prescribing term limits for senators up to 3 consecutive terms at a time, and establishing the corresponding election cycle for the Guam Legislature. I introduce this bill because I believe that it is good public policy, and it is an issue that has gone back as far as the first Guam Legislature. But now I believe is the right time to reintroduce it to the public. Lengthening the terms from 2 years to 4 years benefits the public in several ways. I believe that the 4 years provides an increased opportunity to acquire depth of knowledge required to address complex policy issues and to master legislative skills to develop legislative initiatives. We all know that a good degree of expertise is required to function effectively in any body. The increasing the term also, in my opinion, increases the incentive to serve and attracts better qualified members who are willing to make the time commitment to a 4-year period in office. I also believe that a 4-year term means that elected officials will spend greater time on their term on statesmanship and policy and lesser time on the campaign trail. Insofar as staggered terms, we understand that the Organic Act provides for biannual elections in even-numbered years. And from the beginning of the Guam Legislature, from the first, it has been a 2-year term. I believe that So what we did in this bill is we provided for staggered terms in a method that would provide for 8 members to serve a 4-year term in the initial election in 2018 if this bill should pass, and the other 7 to be elected to a 2-year term. At the subsequent election, there'll be a slate of candidates running for a 4-year term. We'll recharacterize that. So the idea is every election you'll have a slate of candidates, either 8 or 7, that will be running for re-election. Term limits have always been thought to limit the balance that is needed for professional politicians with the public's desire to avoid career politicians. Limiting term limits would increase the rotation into and out of office and change the background and perspectives of those serving in the legislature. But this bill doesn't go so far as to implement a lifetime ban on senators. And with that, I don't want to spend too much time with my position on the thing, and I welcome all those who have come today to testify on the bill to do so. Thank you, Mr. Chair.
Thank you, Senator Torres. Signed to testify for Bill 92-34, we have Mr. Ken Leon-Guerrero. Please join us, sir. We have written testimony that's been submitted by Mr. Darrell Taggery that will be included in the committee report. We have Mr. Sedfrey Lingsangan, who's also signed up to testify. Please join us, sir. And we have in big, bold letters a single name, Klitsky. Please join us, Senator Klitsky, for your testimony here this morning. We'll go ahead and begin in the order of sign-up. So, Mr. Leon-Guerrero, whenever you're ready, you may begin.
My name is Ken Leon-Guerrero. I'm the spokesperson for Guam Citizens for Public Accountability. I'm here today to testify against Bill 92. This is a bad bill on a number of levels, and starting with the 4-year term. The 2-year term gives the people of Guam plenty of time to determine whether or not a senator has is in service of the public or in service of special interest. And a 4-year term basically protects incumbents. When I say it protects incumbents, the author of the bill said that the 4-year term will allow senators to learn their craft. This would be the only position within government in Guam that we give that length of on-the-job training. And I don't think it's a wise use of taxpayer money. The second aspect, it is hoped that with the 4-year term, candidates and senators would spend more time doing the people's business, less time fundraising. And nowhere in the legislation is there any limit that says no fundraising activities can start before the January 1 of the final year of the 4-year term. So therefore, candidates will have a 3-year protected, unchallenged shot at fundraising, because no donors in their right minds are going to be donating money to candidates, new candidates 2 or 3 years out. So the net effect is that the 4-year term protects incumbents from challenge from new people, provides 2 years of mediocrity with the effect of a get-out-of-jail-free card, because there's going to be such a long time between elections. The other thing that I don't like about Bill 92 is the fact that it provides protection for the senators. If this law had been in effect during the prior to the 2016 election, we would still be playing games with the pay raises. We would have the senators who are not going to be up for election for 4 more years. They would be the ones that would be carrying all the risk, while all the senators who are up for election in 2 years are going to use this opportunity to give the safe and popular votes, hoping that the public will forget the 4-year senators due to changes and the newest crises. So what I see with this 4-year splitting the legislature in half, we're going to be pitting one half of the legislature against the other half when it comes to unpopular topics as far as the public is concerned. Under the current 2-year term with everybody on deck at the same time, it strips away the possibility of those types of games as we saw in the 2016 election. The other aspect about this bill that and I'm not the only one, don't particularly care for, is the fact that it claims that there's a limit, 3 consecutive terms. That's not term limits. If it was 8 years consecutive or 12 years lifetime, that could have been construed as a term limit. But we don't need term limits. We have one. It's called the biannual election. So on that basis, the Guam Citizens for Public Accountability is in opposition to Bill 92.
Thank you for your testimony, Mr. Leon Guerrero. I understand also that Mr. Taggarty's testimony has been submitted in writing, indicative of being on behalf of the same organization as well?
Yes.
Okay.
He is a member of the Guam Citizens for Public Accountability. He has asked that I submit his testimony into the record. Honorable Michael F.Q. Nicolas, Chairman, Committee on General Governmental Operations and Foreign, Federal, and Regional Affairs, 34th Legislature. Dear Mr. Chairman, thank you for soliciting the viewpoint of the public regarding Bill 92-34. I also commend Senator Mary Camacho Torres for proposing term changes in an effort to improve the effectiveness of those we elect to act in our name. I cannot support these changes, however. Extending the term length to 4 years removes the people's power to replace ineffective salons every 2 years. And the 3-term limit would limit our preference for superior incumbents. Reducing elected officials' regular and periodic accountability to voters should be more compelling than the desire for professional development. The need for senators to learn their craft has not been an issue over the 67 years of this institution. Those campaigning for office should know what contribution she will be making. Mason's Manual of Legislative Procedure is a powerful tool that takes time to master. The party caucus sets priorities. Experienced staffers provide institutional knowledge. Most importantly, elected officials bring their own perspective to the discussions and to their votes. We, the people, rely on diverse viewpoints to resist lobbying by special interests. Perhaps this is the best time to remind everyone that the public's interests are better served when the legislature had 21 members. Cutting the legislative budget was the rationale for cutting the number of senators, but practically speaking, senators' budgets were maintained at roughly the same level while representation of our interest was sacrificed. What else changed? First, senators' staffs are smaller and more professional. Second, special interests need to reach out to fewer senators to get their way. New senators have not become more professional or arrived better prepared, but they're not supposed to. They can arrange for freshman orientation and training, and they can retain experienced staff. They can caucus and reach consensus or not, and then vote. The bill's author is right that it takes time to find one's place in the legislative power pool. But the measure of effectiveness of the legislature is whether its members as a group can, 1, establish standards that apply to all of us, 2, budget to enforce those standards, and 3, oversee public agencies. Everything else is simply abuse of elected office and of no public value. Instead of debating this bill, real progress would be for all senators to concentrate solely on what you are elected to do in our name. If you are having difficulties, reform your offices to staff a central pool of professional staff and plan for a more representative 21-member part-time 35th Guam legislature. Use your time in the current term to make this branch of government more representative, professional, and effective. Who am I to advise you of this? For those of you who may not know, I have served 5 different senators as a policy analyst over the past 30 years. I have seen what works and what does not, and why. Instead of tinkering, you can advance directly by adapting tried and true methods implemented elsewhere within the Western Legislative Conference area. The people of Guam are suffering from official neglect and mediocrity. We are looking for better. You can take the power and resources allocated to you to establish standards, budget, and oversee executive agencies, and to the extent that you don't, we the people hold elections every 2 years until we have representatives who meet our needs and advance our aspirations. Thank you for considering my perspectives on Bill 92-34 and its intent to improve our community. Sincerely, Darrell A. Borja Taggarty, Member, Guam Citizens for Public Accountability.
Thank you for reading Mr. Taggarty's testimony into the record, Mr. Leon Guerrero. We also have signed up for Bill 92, Mr. Kin Perez. Kin, are you going to be joining us, presenting orally? Okay. Next on the chronological listing, we have signed up Mr. Setfri Linsangan. Sir, you may begin at any time.
Half a day. Thank you very much, Mr. Chairman, Senator San Nicolas. Good morning. Good morning, Senator Torres. Senator San Agustin, good morning. Well, first of all, I would like to thank Senator Torres for her accomplishment, for introducing so many bills. Even some have not made it, at least through the course of discussion in the public hearing. Something might come out which warrants legislation. Well, in the primary election, like if you're not in the top 10, if you're running for senator, most likely you will not make it in the general election. Same thing in the Republican. If you're not in the top 8 in the primary, there's a good chance that you will not make it. That's why primary election is very important. On the other hand, biennial election or your bill to extend it to 4 years, I believe have some Organic Act issue which Congress needs to clarify or be amended, which we have no authority. Okay? But before I went into that, let me present to you my personal opinion. To me, I disagree with your bill because if the economy is not working good, if things are not fairly well, then we need new senators. In the U.S., there's like only 100 senators out of 50 states, but they are not making laws. They're only ratifying it because the congressmen, around 435 and 6 non-voting delegates are the one making laws. Now, there's a reason why the Congress incorporate that subsection D in the section 1423 of that pertains to Legislature of Guam. It is clearly specified there that the general election shall be held on the Tuesday next after the first Monday in November, biennially in evenly numbered years. Now, in this section 1423, there is no terms of office that is specified by the Congress. Therefore, by interpretation here, is that the terms of office for Guam Legislature is 2 years. Why? Because in the U.S., the 459 congressmen and women are elected every 2 years, and their terms are 2 years. And then in the states, they're state legislators. That's why it's important that we preserve the full-time legislature. Now, we don't have the position to, in my opinion, to amend the law because of this provision. It's very clear, biennial. You can think some loophole, but still you need some clarification from Congress. Because it's like we are being like mats to the congressmen in the U.S. that their terms are only 2 years. And again, in section 1423A, regarding the scope of the legislative authority, the legislative power of Guam shall extend to all rightful subjects of legislation not consistent with the provisions of this chapter and the laws of the United States. Now, there's so many provisions in this chapter that you have to follow the laws and the Constitution. Just like when you serve as senator, you need to take oath of office, as is specified in section 1423K, and every officers of the government of Guam, that you solemnly, in the presence of Almighty God, support the U.S. Constitution and the laws of the United States applicable to Guam. And yes, because of that, I noticed that there's some also instances like this that needs deliberation and clarification. But the issue that I have in mind, I think is very clear, Mr. Senators, and I'm referring to the primary election of the gubernatorial candidate and lieutenant gubernatorial candidate. Now, let me make a supposition. Let me suppose a case for a moment. In case 5 of the senators, because it's related, it's about election reform. In case 5 of the senators, incumbent senators, would like to run for lieutenant governor, in our law, it needs to be tandem. But the gubernatorial candidate disregard you, bypass you, because he has his own choice. Therefore, your constitution is being violated. You see? Just like in this bill of Senator Torres, he said 8 senators will be elected for 4 years, and then the 7 senators for 2 years. It's a violation of the Section 1 of the 14th Amendment, no state will deny any person within its jurisdiction the equal protection of law. See, there's an inequality issue. It's just like somebody would like to run for governor and he cannot find a running mate, and then because of the law that you created, he cannot run for governor because he cannot find a running mate. And same thing with the position of senators or anybody that would like to run for lieutenant governor but cannot run because of this law, because Guam election will disqualify them. See, and there's a relation between the section 2 that was introduced in this document. See, then another equality issue is you require the OPA, the CCU, and the Attorney General to run for office without any nominating petition, wherein you require the poor board members of education 100 nominating petition, the governor, lieutenant governor 500, 250, 100 for such and such. You see? And then, in regards to the mayor and vice mayor in Guam, there's another inequality issue. They can run for mayor without running mate, and then for vice mayor, they cannot run. What I meant is, vice mayor can run separately, and mayor can run separately. That's inequality issue, referring to the governor case. Because in the US, the system is the governor and the lieutenant governor can run separately in the primary election. In fact, up to the general. But we cannot do it in the general because there is a provision in the section 1422 that there needs to be they need to be chosen jointly. That's why, Senator Torres, I think there's a conflict here. There's a problem with the law pertaining to Organic Act. And yeah, just like my own personal opinion, it's once you get elected, then some of you, we cannot even meet in their office or even have a telephone call for a few minutes. That's my frustration. And the campaign starts once you get elected. That's what I meant. You don't even have to worry about being re-elected if you will be true to your promises. See? And lastly, I would like to thank all of you for passing the budget and amending it from biennial to annual, because the budget hearing is the mother of all oversight hearing. That's because that's the training ground for all the senators to become governors in the future, because you're dealing with implementation. Because right now your experience is writing law, not implementation. If you will skip the 1 year, I hope it will not happen again, then you will have a lot of chance to shine. And I would like to thank the governor and the speaker, B.J. Cruz, for introducing that bill. At least it's no longer a mystery. It was thoroughly deliberated. And you know, yeah, I can empathize with the senators, incumbent senators, because in the U.S., the senators are getting $174,000 salary, and the congressmen are $164,000. You know, and the reason is it needs to be consistent with the other branches of government. Why? Because once your salary is not in line or with other branches of government, then it will diminish your effectiveness in conducting oversight hearing. You'll be conducting chiefs of agency that are making $100,000+, $90,000. You're inferior already, and that's why the U.S. raised their salary. And besides, you pay for your own salary. Just not support those bills that will just make the government better. You already paid for 1 year of your salary. The 8.3 million of your budget is nothing compared to the bills that you will pass that for the best interest of the government of Guam, also for the conducting oversight hearing. As long as you treat them with respect, because they have more knowledge in that field, all you have to do is guide them, treat them great, and they will show themselves great. But if they will not cooperate and will be disrespectful, hold them in contempt. Jail them here for a few hours or 1 day. That's what other countries are doing. You should not let anybody from the government agency attack you, especially in the hearing. You have a very powerful position. You can hold budget. You can jail them here for a few days. Hold them in contempt because they need to cooperate. But just like what I said, treat them greatly and they will show themselves great. Thank you.
Thank you for your testimony, Mr. Lingsan. Next signed up to testify on Bill 92-34, we have Senator Klitsky. You may begin whenever you're ready, sir.
Thank you, Mr. Chairman. Mr. Chairman, before I begin, I'm going to have to confess some naivete. When I went to prepare my testimony for Bill 92, I went to the legislative website to find the bill. So my testimony is based on Bill 92 as I found it on the website. I didn't have the one that was corrected by the prime sponsor. However, having glanced at it and having glanced at my testimony, I think that the somewhat understated points that I make in my testimony are as valid with the bill as corrected by the prime sponsor as they were with the original bill. So I'll proceed. There's just one place where I would ask your indulgence to make the mental correction to what it is that I'm trying to say. Honorable Senator Mike San Nicolas and members of the Committee on General Government Operations, assuming the germaneness of the bill, and that's quite an assumption, I will address the amendatory provisions seriatim. The amendment to the first sentence of 2 GCA section 1105 would provide for senators elected on November 6, 2018 to serve until January 2, 2023. In politics, timing is everything. Given what Andrew Bainum has labeled the smash and grab of November 21, 2014, a 4-year term is not at all attractive. Consider, had this bill become law in 2014, the opportunity, that is short of recall, to turn the rascals out would not have occurred until next year. No thanks. Lest we forget, on November 21, 2014, 17 days after they were elected or re-elected, Lieutenant Governor Ray Tenorio and 10 members of this body helped themselves to a $25,000 per annum raise retroactive to almost the beginning of the term. This huge ripoff was accomplished without a public hearing or a certificate from Speaker Wampat attesting to an emergency. Because Ray Tenorio called the legislature into special session and sent Bill 8S, the salary bill, there was no notice of the special session. With little more than an hour of discussion, the bill was passed and transmitted to Tenorio. As the acting governor, Tenorio signed the bill on the same day that he had sent it to the legislature. even though the payment did violence to the legislature's budget, the retroactive raises were in the senators' pockets by Christmas. Repeated attempts to right the wrong during the 33rd Guam legislature did not bear fruit, as the Juan Pat 10 was able to hold out against the efforts of the San Nicolas posse. Short pause here. It was only after the rascals had been turned out, that is, lost, that the new legislature was able to remedy the smash and grab. So the old saying goes, fool me once, shame on you. Fool me twice, shame on me. 2 years without the cleansing effect of an election is enough. The amendment to the second section of Section 1105 would provide for term limits for senators. This provision is constitutionally infirm. If this bill were to become law, it would impose a new eligibility requirement on candidates. Thus, in addition to age, citizenship, residence, and lack of criminality, a lack of success as a politician would also be necessary to be eligible. It's a kind of a 3 strikes and you're out type proposition. As a policy matter, there is much to be said in favor of term limits. Many hold that a plethora of professional politicians preying on popular politics can be seen as contrary to the principles of responsible government. Later on today, I'll be speaking about, quote, leveling the playing field, and ending political oligarchies. Term limits can be advanced as remedial in these contexts. However, as long as we are subject to the Organic Act in its current form, this body is powerless to add an eligibility requirement in addition to age, citizenship, residence, and lack of criminality required by 48 U.S.C. Section 1423F, no matter how salutary the added eligibility requirement might be. The United States Supreme Court has spoken to this very issue in a case called Powell versus McCormick. Chief Justice Earl Warren, not exactly my favorite, but Chief Justice Earl Warren wrote the opinion for the court, the majority opinion. He said, further analysis of the textual commitment under Article 1, Section 5 has demonstrated that in judging the merit qualifications of the members of Congress, of its members, Congress is limited to the standing qualifications prescribed in the Constitution. Justice Douglas chimed in and said, while I join the opinion of the court, I add a few words. As the court says, the important constitutional question is whether Congress has the power to deviate from or alter the qualifications for membership as a representative contained in Article 1, Section 2, Clause 2 of the Constitution. Up to now, the understanding has been quite clear to the effect that such authority does not exist. The Constitution lays down 3 qualifications for one to enter Congress: age, inhabitancy, and citizenship. Mr. Powell satisfied all 3. The House cannot add to these qualifications. Thank you, Justice Douglas. So here, eligibility for senator is a list of 4 items. 25, U.S. citizen, 5 years domiciled in Guam, no felonies or moral turpitude misdemeanors. That's it. That's all. You cannot add another bullet that reads no service in the preceding legislature. And that's exactly what you're doing with this bill. Although this result is constitutionally compelled, There is an unorthodox approach that combines the theory of judicial standing with the effect of public awareness and public pressure that I will explain at the end of my testimony, if you ask me to. Even though severability clauses are usually a waste of ink and paper, they tend to be included in most of your bills. You see a one-sentence bill with a severability clause. The severability clause is 4 times longer than the substance of the bill. Footnote there explains sort of the theory and practice of severability clauses. Given the almost certain finding of unconstitutionality of term limits provisions, some thought might be given to the longevity of the 4-year term provision. Consideration of the desirability of the survival of the 4-year term is advised. There's an interesting frying pan fire effect here. If the 2 amendments pass the germaneness test and term limits fall, it follows that 4-year terms must also fall. In other words, a court's willingness to sever 4-year terms is enhanced by a finding of lack of germaneness. In closing, in perhaps a generation, 4-year terms for senatorial service may receive unbiased consideration. A generation's 30 years. I think it's going to take about that long for people to forget about the smash and drag of November 21, 2014. And also, in the absence of an amendment to the Organic Act or enactment of our own Constitution, providing, therefore, term limits is one of those attractive destinations that we can't get to from here. Thank you, Mr. Chairman.
Thank you, Senator Klitsky. Last on the sign-up sheet to testify on Bill 92-34, we have Mr. Ken Paris. Ken.
Thank you, Mr. Chairman. Honorable Chairman, Senator Michaelson, Nicolas, and members of Imina 34 na Legislature in Guam. My name is Joaquin Paris, and I appear before you as a private citizen to express my thoughts on Bill 9234, an act which proposes to make changes in the manner in which members of the Legislature in Guam are elected and other purposes. To begin, let me state that as a private citizen, I wholeheartedly support the intent of Bill 92-34. If enacted, this legislation will increase legislative terms from 2 to 4 years. Guam's Organic Act requires that legislative elections be held every 2 years, so there will be an election every 2 years. If the provisions of Bill 9234 are made effective for Imina 35 na Legislatura, for the very first election, senatorial seats will have to be divided into 2 sets of 8 and 7. For the 2018 elections, the 15 successful candidates will draw lots to determine which seats will serve from 2019 to 2020, a 2-year term, and which seats will serve from 2019 to 2022, a full 4-year term. Every general election thereafter, there will be either 8 or 7 slots on the ballot. I believe that this will reduce campaign expenses, potentially, in half. I do not mean to say that expenditures of the individual candidates will be reduced. What an individual candidate feels he has to spend on his campaign to win is the personal decision of that candidate. However, I believe that the expenses of these campaigns to the electorate, who are the primary source of funding through political contributions, will be reduced. If enacted, the measure will reduce the cost of campaigning, perhaps not for the upcoming 2018 elections, but for sure for ensuing elections. For the 2016 primary election, approximately $541,000 was spent by the candidates of a single party, and then another $414,000 was spent by the same candidates for the general election. Candidates for the other party spent $244,000 for the primary and $310,000 for the general election. So a total of $1,482,000 was spent on campaign expenditures for the 2016 election. The bulk of that money did not come from the personal pocketbooks of the candidates, but from the generous constituents and supporters. I believe that reducing the number of candidates per election will reduce what is being spent for campaigns, money actually coming from the electorate. Doesn't come out of the government coffers. There's much effort being expended looking for ways to reduce the cost to the government of conducting elections. It is my personal opinion that there is very little, if anything, which can be done in this pursuit until such time as the political parties are willing and capable of conducting the primary elections on their own. Absent this, I think it more productive to the electorate and individual voters if ways and means are found to reduce the cost of elections campaigns to those who are actually paying for these campaigns through their individual political contributions. Additionally, by reducing the number of candidates per election, we will see fewer signs along the roadways. As I note, if the size of individual signs were also reduced to a maximum of 2 feet by 4 feet, there would be even fewer driver distractions. There will be fewer commercials on TV and radio, which will reduce stress, tension, and anger among the viewers and listeners. Likewise, fewer flyers and other printed paraphernalia will mean less litter on our streets and byways. I also believe that increasing the length of the individual legislative term would provide more time for the individual legislators to attend to the important work of policy making, not attending to learn how to legislate, but to just pay attention to what bills are on the floor, what the intent was, what the ramifications are. It's a general learning process. I've worked long enough in this legislature to know that no matter how seasoned you are, the minute you come in that first term, there's a lot of learning to do. The law requires legislators to be sworn in on the first Monday of January. For some, that signals the beginning of campaigning for the next election under the two-year terms. By increasing the length of the term to 4 years, perhaps and hopefully, the first or the third years of the term will be put to better use doing actual legislative work. Relative to term limits, I still believe that the best determinant of term limits are the voters themselves. Research was once done that showed that the average number of terms served in the Guam legislature was between 2 and 3 terms. There have been individual senators who have served well over this. Francisco Rivera Santos served 13 consecutive terms, and he never placed above 18 in the 21-seat legislature. I used to have to stay up until 7 o'clock in the morning to learn that he made it past 21. Antonio Reyes Sumpinco served 14 terms, though not consecutive. These two brother-in-laws served the longest, not because they spent the most money on their campaigns. I can tell you this, Francisco R. Santos never had any fundraisers. But genuinely because the electorate trusted, respected, and loved them, and the work that they were doing as representatives of the people. People don't get elected to multiple terms in this legislature unless the people genuinely, number one, first, they have to trust you. If they don't trust you, you're gone. And we've seen this. We've seen this with single, term senators because the people just didn't trust what they were doing. If they trust you, you'll be here for a long time. Likewise, there have been senators who were not elected after a single term. Some of you served with some of those. Just as there were senators who determined for themselves that life in this legislature was just not their cup of tea. Mike Limtiaco and Francis Santos. They quit after Francis a term and a half, and Michael before he even finished the first term. I think that if refined and if the finer points of this legislation is done efficiently and effectively before the 2018 election, it can be made effective in the 2018 election. And I think if the people, sometimes we think that the people won't understand. I think we're shortchanging the people of Guam when we think that they won't understand what the meaning of this thing and what the benefits will be. I would like to see senators in this legislature serve a full 4 years, not because they're going to learn and not because we elect them because we trust them. We elect them because we respect them. Somehow I personally believe that trust and that respect will be reciprocated by those that we elect. I don't like to go into that voting booth and saying, I don't want to vote for this guy because I don't trust him. I want to go into that booth and say, I'm going to vote for this man because I trust him. And for that reason, for those people that I trust, for those people that I do vote for, I want them to be there for 4 years because I think they would be more productive. If you look at all of the bills that have been passed by this legislature in 2-year terms, some of them you had to go back real quick to fix because maybe it was passed too soon, too quickly, without really good, deep thought. And guys, you guys, the 15 of you are really capable of doing that. We just have to put that trust a little bit more into it and say, okay, you got 4 years to do what we think you can do and what we trust you will do. Thank you for this opportunity.
Thank you, Mr. Perez. I'm going to open up the panel for any questions of this body, and then I'll allow for the sponsor to make a closing statement after we've asked any pertinent questions. Do any of my colleagues have any questions for this panel? Senator San Agustin.
I only have a question for Mr. Perez. So you're recommending, Kim, that instead of the 2-year, it'll be 4, and instead of waiting the way the bill is written, that 8 of them will get 4 years, and then the other 7 will get 2. It'll be one shot, 4 years. No.
You'd have to stagger their terms. Some of them for the first election. Everybody gets elected in 2018. 2 of them, or half of them, will have to be reelected or rerun again in 2020. The other half, the other 7, can stay on until 2022.
So you're saying, as you said, your last statement was that you'd like to see a senator sit for 4 years is not totally true then. You want to do exactly how the bill's written, not giving a full 4-year one. In other words, in 2018, the election comes, a senator's, some will serve 4, some will serve 2. That's how you want to keep it, not everybody serve 4 years and be done with it.
The reason for that, my primary reason for that is the fact that you're required by the Organic Act to have elections every 2 years.
So regardless of the bill name, then it doesn't matter the 4 years, it's every 2 years. Okay, thank you.
My other reasoning for that, Senator, is the fact that you're always going to have at least 7. You know, an election can occur, but there will be 7 guys still sitting in this legislature. There's no reason for, many times I've noticed that between the primary and January, nothing really happens because of the campaigning period, the election period. If you have 8 of those guys who do not have to face a re-election in November, that half, that 8 or 7, whatever the case may be, can still be doing their legislative work while the other guys go out and campaign. There's got to be, I think it'll promote continuity even among the ranks of U15. Because somebody's always going to be there, and not necessarily out there on the stump.
Any of my other colleagues have any questions for this panel? Okay, is that a question or? Oh no, I'll yield if you have a question. Yeah. I do have a statement also that I wanted to kind of put to the panel, but okay, thank you, Senator Torres. You know, when I was reading the bill, I understood the intent, and I know that there's been some testimony from this panel about on-the-job training and the need for senators to kind of develop and to learn. And I kind of wanted to put this out to this panel because I really appreciate the feedback that we're getting on the bill, and I wanted to ask what your thoughts were about this. When I first got elected in the 32nd Guam Legislature, and this happens to every single senator who gets elected, we take office in January, but the budget is already inherited. It was passed in October. And so senators come in January, they inherit a budget that was passed by the previous legislature. And like, for example, this legislature, we had 7 members go out. So when you inherit a budget in January, you really only have one budget that you impact as a newly elected senator, and that's the budget that coming October. And so from January to October, you got to figure out the budget of the government of Guam. You've inherited one, you go to these hearings and you listen to agency heads come in and make their case. You have B.B. Marg coming down and providing their figures. And as a newly elected senator, I'll just share with you my experience. You really just have to take a lot of it at face value. I had to rely on the perspectives of colleagues at the time. And then when I sat in hearings, I took a lot of the statements from agency heads at face value. And to be quite frank, I made a lot of mistakes my first term because the information that I was receiving was not necessarily accurate. And it took me at least a couple terms before I really figured out that, you know, we have people saying the finances are good, but they're really not. And, you know, I definitely wouldn't have figured that out in the first 6 months of me being in office. So how do we reconcile, because I listened to the challenges that the Organic Act presents with respect to changing the term or providing term limits. But how do we reconcile the need for us to make sure that senators are receiving accurate information and learning what the actual truth is in order to make factual-based policy versus this challenge where you kind of get elected, you inherit a budget, you have a crash course 3 to 6 months to get information you don't know or it's too difficult to validate within that short time period, and then you got to pass a budget again that October. How do we solve that problem if it's not going to be through extending terms of senators? Mr. Nicolas.
Well, the first thing is you inherit a budget, but you do pass 2 budgets because the next legislature is going to inherit your second budget. So you do pass 2 budgets. The way we solve this problem right here is we go to a part-time legislature that allows us to do 2 things. One, we can see a higher caliber of candidate running for office, the type of people that can't afford to take 2 years out of their career paths, but they could take 2 months out of each year to serve. The second thing that we do is we create a professional staff. We eliminate all the temporary hires so that the central staff builds their skill set, their knowledge, their experience and resources, and they become the assets to the senators as they take their seat. But right now, as a result of what happened in 2014, the trust has to be earned back because there is no way the public is going to sit through this 4 years where half the legislature protects the other half. So we'll see the same types of games we saw happening in 2015, where every senator could swear on a Bible, we voted to roll back the pay raises, but the net effect was after 10 bills, it took the 34th to roll back the pay raises. So with this 8-7, I see that rolling forward ad nauseum. Now, the second problem I see, how are we going to determine who's the 8, who's the 7? Are we going to do paper, rock, scissors? Are we going to draw ballots? Are we going to flip coins? No matter how you guys put it down, there's going to be a lawsuit. So now we're going to be bringing in all the attorneys because I shouldn't be a 2-year, I should be a 4-year. How are you going to get away from that? I didn't see anything in the mechanism that would pass the legal proof test. So I think that this bill creates a lot more problems than it solves. Later this afternoon when we talk about 60 and 61, I think we're going to be able to address that concern, because if you'd inherited a professional staff that has years of experience dealing with these types of things and the budget issues that you can use as a resource, as opposed to starting over fresh, that would be an asset. And number two, I think this new crop of senators is proving my point, because I've been involved in the legislature off and on since '07, and in this new group of senators, I'm seeing a level of professionalism I didn't see in the 30th, 31st, 32nd, and 33rd. I'm seeing more attention to detail than I've seen in those previous legislatures. So I'm encouraged at the evolution we see in the quality of candidates coming forward. And I think going to a part-time legislature, we will see that evolution continue as more people with higher skill sets and higher caliber experience are able to come into the legislature and bring that experience with them.
Senator Clancy.
Thank you, Mr. Chairman. With respect to your question, the legislature is not bound to do the budget on the schedule that it does it right now. During the time that Carl Gutierrez was a senator, I don't remember if he was Speaker or Chairman of Ways and Means, but they did a 3-year budget, and each budget was reduced 5% from the one before it. They had a 2-year budget proposal before this legislature, which didn't go. The fiscal year used to end, you younger folks wouldn't remember this, but the fiscal year used to end on June 30, so we did the budget much earlier in those days than we did now. So you're in a position now where you could tailor the schedule of the legislature to avoid the problem that, or what you see as a problem, Mr. Chairman. As far as on-the-job training, et cetera, I guess I'm old-fashioned, but I don't think there should be any on-the-job training. If you run for senator, I would hope that you're serious enough about doing it, that you have done extensive reading and studying, et cetera. Maybe even do something as radical as go around and talk to old people that have been there before. I know that's really a kind of an edgy suggestion, but might work for you, Joe. But so that the day that the legislature is first called into session, you are not stumbling around, not knowing what to do. Mason's rules was mentioned. Mason's manual was mentioned before. There's a book called Sutherland, actually a 7-volume treatise called Sutherland on Statutory Construction, which is a goldmine of information. So have a grain of salt handy as you consider those things. But I do want to point out one thing that I just noticed in the bill as corrected by the author. The way the bill is constructed, if it became law, after the first election, the election commission would have a lottery to see who had the 7-year, as you were the 2-year and the 4-year term. You're arming everybody who wound up with the 2-year term, because the Organic Act says that you get into the legislature by being elected, not by lottery or something like that. So I would be very surprised if someone didn't challenge that, and I would be very surprised if the challenge didn't bear fruit there. If this is what must be done, then I would suggest that there has to be a different way of going about doing it. I can't tell you what it is right now, because I just spotted this right now. And besides that, I'm not in favor of a 4-year term anyhow. Thank you, Mr. Chairman.
Thank you, Senator Pietzke. Can anything to offer? Or?
You know, I was around when 21 seats changed. I'm sorry, not 21, 17 seats changed. And you had 21 Democrats removing 17 Republicans. When that kind of a shift changed, and it's basically it's no different than this last election when you had 7 seats change. changing that number of seats in in anybody can be traumatic, and I guess you're experiencing it now. But when we study you guys, when you guys put out your pamphlets, and we study your backgrounds, and we study what you've done, and what we assume what your potential for doing is going to be, we develop a level of trust. And your election, being elected, should be your signal that, hey, you know, I've got 19,000 people that trust in my judgment. So I'm going to be as wise as I can. I'm going to learn as much as I can. I think that the entire relationship between electorate and the senators, those who run for office and who are successful in office, speaks to only one word: trust. And if we can't trust each other, then really some of us are not necessary. And I would like to see this legislature go back to 21 members. Because right now, with that court ruling, that court case that's going on, you're going to have you may have a situation where 5 of you can determine what the law is going to be. Supposing only 8 people show up for a session. The majority of that 8 is 5. You're going to have laws being made by 5 people. That's not what we voted for. You know, that's not what we as a people want. And so we leave it up to you to be as wise as what we thought you would be when we voted for you. Other than that, Senator, Mr. Chairman, people that say that when you get in here, particularly when you're a freshman or even a sophomore, to say that you're already supposed to know what you do when you're going to get in there, I don't buy it. I worked for this legislature for 10 years as a senior staffer to Senator Frank R. Santos and Francis Santos and Antonio Umpinco. And every time they got elected, it was almost like brand new, even for them, even for Francisco R. Santos, who was in here for 28 years. I don't know. Take it from, you know, that's what I learned. And if I can't trust you, I won't vote for you. In fact, I may campaign against you. But if I trust you, I want to trust your judgment. If I don't trust your judgment, then I didn't do a very good job on my own judgment. And I don't know, I'm hoping that one of these days, the electorate on this island will come to the conclusion that it is a game of trust. And for those people who bash and who want to get into fights with the legislature, hey, there's a simple way to solve that. Put your name on the ballot. Come to the election commission, pick up a petition, and run. And become a senator. And if you can't do that, then hold back and come to these public hearings and express your views. That's all I got to say.
Thank you, Mr. Perez. Yeah, I just wanted to pose the question because, for me, when I read the bill, I understand the intent is to try and create a legislature that's going to be better informed when it comes to decisions that it makes. And, you know, just from my experience, I'll just be very upfront. My first term was a crash course in, you know, what you see in front of you isn't exactly what the truth is. And it took a while for me to really not only come to terms with that, but also to develop the research methodologies and the mechanisms to be able to go out and find that truth. And then the added challenge of trying to communicate that truth, making it something that the public is aware of, and then just being able to hold the line and advocate for it. And then even in the middle of sea changes that are elections, I mean, it just creates a whole new dynamic because you're almost having to start that process all over again every 2 years, where I may have certain facts that I've already become very comfortable with, but a newly elected senator is going to be hearing all kinds of other information, all kinds of other data sets coming from people who are supposed to be presenting facts that are not necessarily doing so either. And it's not necessarily a fault of the new member to take it into consideration, because I've been there. And as a new member, you want to try and listen to everything as well. But it gets challenging because it's only after a certain period of time where you begin to realize, hey, you know what? This person came down here and testified 3 times that we have money and we actually didn't. I'm not going to be buying that, I'm not going to be buying that can of beans anymore. But when we're in those kind of environments, it just makes it very difficult as elected officials who want to honor that trust to be able to do so with facts. And that's why I wanted to pose the question, because in the end, our quality of service as elected officials is only going to be determined by, of course, 1, our character, and 2, our capabilities, but 3, the information available. And it's a challenge. It's a challenge getting to the facts sometimes. But I do appreciate the sharing of the wisdom here today. I think that a professional body in the legislature, as far as staff goes, that would be consistent with the Congressional Budget Office. I think that's something that can definitely be looked at. The part-time legislature thing, I think that there's just a lot of other facets to that, but we'll be discussing that in future legislation. I am concerned, and I share your concerns, Mr. Perez, about the court case. I mean, but even if we go to 21 senators, technically you only need 11 for a quorum, and then you only need 6 to make law. So right now you will only need 5 of a quorum of 8. You'd only need 6 of a quorum of 11. I mean, that still is a dramatic amount of legislative authority in the hands of so few. So I really hope that our Supreme Court justices think very, very hard about how this is all going to turn out. That being said, thank you very much for providing that information. I wanted to yield now to the author for any questions and for her closing statement if she had any.
If I could, I'd just like to make a comment on your last statement. What we have seen between the 32nd and 33rd and this legislature is that with the new senators coming in, the level of attention that they are applying to their craft, they are in the process educating the executive departments on what is expected. Because I know from my own experience that in one department where I looked at their paperwork, their executive director was lying. He was signing off documents that had no basis in reality whatsoever, And I think the fact that this legislature is drilling down into more detail, doing a closer examination of the paperwork to make sure that the numbers actually do have some basis in reality. And in the oversight hearings, I have seen a level of questioning that I did not see. I first started going to oversight hearings in 2007. And in this legislature, I have seen a level of interaction and drill down that I had not seen in any of the previous legislatures. So I think the turnover worked and helped. I think that this body is setting new standards on how the legislature and the rest of the government will be interacting going forward. And I think that will only get better as we increase the number of senators and increase the level of competence and the quality of the people running for office.
Thank you, Mr. Leon. Senator Torres.
I want to thank everyone for coming out today. The last time this issue was brought before the legislature was in 2009, a bill introduced by Speaker B.J. Cruz at the time. And interestingly, only one person showed up to testify at that time, so we've come a long way. I introduced this bill because I sincerely believe it's a better system for our government. And when you think about the number of terms that exist right now with elected officials, the legislature is the only one with a 2-year term. You have the governor, the mayors, the OPA, the public auditor, and the attorney general all serving 4-year terms. In addition, you have although not an elected position, the Justice of the Supreme Court, the Chief Justice, is limited to a 3-year term. He is, in essence, elected in the sense that he's, or at least retained by the population. But the legislature doesn't. So this concept, this argument of needing to have a 2-year term to get rid of the rascals at your discretion doesn't really hold so well, because then that same policy should apply to the other elected positions. Unless, of course, you're using the legislature as a whipping boy, which in recent, that has been the case. But I wanted to also mention that there's been a lot of concern also about fundraising and the opportunity for fundraising over a 3-year period. But when you think about the way the Guam Election Commission is set up, there's a requirement for a declaration of candidacy and a filing requirement also for all funds that are raised. So there has to, you know, I believe that the fundraising abuse and misuse is regulated by the Guam Election Commission already. And there was a lot of discussion also about the inorganic nature of this bill. And that issue, of course, is the first thing that I considered when I was writing this legislation. There's been a long history of this issue in Guam, the Guam legislature, going all the way back to the first Guam legislature. There was a bill number 230, that was introduced by E.T. Calvo, which was signed into law as Public Law 1-75. We can make the argument that the fact that that passed and was signed into law and was not repealed by the Department of Interior or the U.S. government, which is their prerogative to repeal any laws passed by this body, that it feels is incorrect, that did not occur at that time. So the argument can be made that the case for a 4-term legislature passed the test. And the only other time that I saw it was addressed, and this was specific to term limits, was in an AG opinion in 2013. But even in that opinion, the Attorney General at the time acknowledged that there were differing court opinions, and that his recommendation to Senator Yamashita was to go the course of the more conservative. He didn't come out outright and say it was inorganic. This case, if it were ever tested, would be a case of first impressions. But in my review of it, with my staff attorney and also in consultation with the Legislative Legal Counsel, the inorganic concern was not something that was raised to me as a reason not to proceed with this legislation. I also want to end by talking about the trust that Mr. Perez brought up. One of the incentives that many of us believe is an incentive to attract more quality candidates and candidates that are committed is by affording them a longer term. But it's not only an advantage to the person who wants to demonstrate that they're committed. I think it also gives us as an electorate the opportunity to better vet people. If you knew, as you do with a governor, that you're stuck with them for 4 years, and I use the operative word stuck because a lot of us have this desire to flesh out people that we find undesirable or who aren't meeting our expectations. Having a 4-year term, I believe, will force our population to pay more attention. I remember on the campaign trail, there are many people who said, and I found it so comical, they would say to me, oh, it's time to send the old ones to pasture and we'll take a chance on the new ones. I don't believe taking a chance is what we're really after. What we're really after is seeking those candidates who we believe have demonstrated within reason that they are qualified to run. So we are at a point in our history, and I looked at this matter, the history of this matter. It was first posed in 1952 in the first Congress, and it was passed into law. In 1956, it was repealed by the third Guam legislature. But interestingly, there was also a climate there where there was political turmoil, where the Popular Party, the one party on Guam, split, eventually went off to be associated with the National Party, Democratic Party, and the Territorial Party that was formed at the time eventually went off to be endorsed by the National Republican Party. But we had those circumstances that perhaps had led people to do what they did at the time and reject certain things. So 1956 was a pivotal time. 1970 was a pivotal time in our development as a political entity when we had the election of our governor. We also, at that time, became more of a part-time legislature than in past. 2009, this issue was brought up again. And interestingly, it has had bipartisan support. So the advantage to one or the other is never the issue here. And I believe that, we've come at a time now where we do need, just in all practicality, to come up with a system that makes sense, that doesn't tax us as an electorate and as citizens who are interested in serving, tax us unreasonably in having to expend so much effort, so much resources, our personal resources and the resources of our constituents to get elected. So I believe the test has been made. We at a time when we had oversight by the Department of the Interior to undo, and to this day they can undo any laws they can repeal any laws passed by the legislature per the Organic Act. They did not repeal that one. That one also called for staggered terms and staggered elections. So I want to thank you for your input. All things will be taken into consideration. If there are amendments needed, the use of the word lottery maybe not be the operative word, but the idea there was to not provide an unfair advantage to anyone in determining how only at the first election and how you would place those people. So we will give a lot of thought to the comments made today in the testimony, and I just want to thank you very much for coming out today.
Thank you, Senator Torres. This will conclude the hearing on Bill 92-34. If there are any substantive amendments, we will, of course, in conformance of our standing rules, have a second public hearing that will be noticed to the community. Moving on to the agenda today, we have Bill number 156-34. And I'd like to thank the panel, by the way, for your participation. Bill number 156-34, an act to amend Section 15201 and 15206, both of Article 2, Chapter 15, Title 3, Guam Code Annotated, relative to changing the date of the primary election and the date of filing candidate nomination papers. We have signed up to testify for Bill 156, Mr. Ken Leon Guerrero. Please join us, sir, as well as the Executive Director of the Guam Election Commission, Ms. Marina Pangilinan. Ms. Pangilinan, you've submitted written testimony to the committee. We'll go ahead and just include it on the record, but please make yourself available for any potential questions with respect to the testimony you have submitted. And at this time, I'd like to yield to the author, Senator Camacho Torres, for her opening statement on Bill 156.
Sus Masi, Mr. Chairman. Bill 156 is an act to amend sections of Title 3 Guam Code Annotated relative to changing the date of the primary election and the date of filing candidate nomination papers. Essentially, this bill was introduced as I believe that moving the primary election just a few weeks earlier could save taxpayers a significant amount of money. And I won't discuss necessarily the director's testimony at the recent budget hearing, but essentially this bill is in response to our general desire to find more efficient operations within the government that are not only better for the conduction of business, but also that can result in a cost savings to the government. So with that, I will yield to the panel.
Thank you, Senator Camacho Torres. Mr. Leon Guerrero, you may begin anytime.
I'm testifying against the bill. I think the better option would be to pass Bill 45 and eliminate the primary in its entirety, because we have gotten to a point now where the people of Guam are in essence paying for what is a party function. The way the primary system is set up now, it's very discriminatory to people who are not members of the elite or the party. So therefore, the taxpayers have no business funding it. If the parties desire to have a primary to select candidates that will represent their party in a general election, that is entirely up to the parties, and in that case, the Guam Election Commission should not be part of it in any way, shape, or form, and concentrate their efforts on supervising the general election.
Thank you, Mr. Leongoro. So just to clarify, your testimony is not necessarily with respect to the actual changing of the timelines. It's just a general lack of support for primaries.
It's a lack of support for this bill and a lack of support for the primaries.
Okay. Do you have any specific testimony with respect to the changing of the dates?
I have no testimony for the changing of the dates other than to say I'm against the bill in principle, because it implies that taxpayers are going to continue to fund what is essentially a non-governmental function.
I understand. Thank you for the clarification. Ms. Pangilinan, we do have the written testimony of the Election Commission. Did you want to read that into the record, or did you want to just append it and then be available for any questions?
Just append it as part of the...
Sure. Senator Torres, do you have any questions for this panel?
I just want to thank you. Mrs. Pangilinan, I know that you had one recommendation. Actually, there's one section that we overlooked, so I appreciate you taking the time to look at that and making sure that where it was applicable to one section, that there was a corresponding change. So we will note your recommendations for the record and make the amendment accordingly. Thank you.
Senator Torres, did you have a closing statement on Bill 156? Okay. That concludes the testimony and statements on Bill 156. We will go ahead and consider the bill having been heard. Thank you, Ms. Pangilinan. This takes us now to the next item on the agenda, Bill number 158-34, an act to repeal and reenact Section 3108 and to amend Section 3202, both of Chapter 3, Title 19, Guam Code Annotated, relative to names on marriage licenses. I'll go ahead and yield to the author now for her opening statement, Senator Mary Camacho Torres.
Zeus Maasi. Bill number 158-34 seeks to modernize Guam statute regarding the choices of name upon marriage. It allows for applicants for Guam marriage licenses greater options to change the middle name and surname by which each party wishes to be known upon marriage. Either party who desires to change his or her middle name or surname may indicate such election in a marriage license application. This bill strengthens, I believe, the measure in 2015 when we passed the Guam Marriage Equality Act, which removed the language in Guam law statute that defined marriage as a union between persons of opposite sex. The intent of this bill is to update sections within Chapter 3 of Guam Code Annotated to ensure that it corresponds with the current statutes pertaining to equality in civil marriages by providing name equality for spouses upon marriage. One thing that I found practical is currently under Guam law, there are really only 3 options that are given to us upon marriage in terms of name selection, and that is to either retain your surname, to adopt your husband's name, or to hyphenate your surname with your husband's surname. We've eliminated husband, I'm sorry, it's spouse. But what that doesn't do is it doesn't provide for what you do with your middle name. And in the practical sense, if for example, I wanted to keep Camacho or make Camacho, which was my given name, my middle name, under Guam law, technically I can't do that. And so what has happened of late is when that has been challenged with certain people who have tried to do that, they were advised to go to court and get a name change through the court system, because technically you're not allowed upon the marriage license to indicate what your choice of middle name should be. So I should have been, for example, if I were named Mary Lou, I would have been Mary Lou Torres as opposed to Mary Camacho Torres, the way the law is written. So this is just an attempt, pure and simple, to provide for that latitude, and especially with the Marriage Equality Act, where the new family dynamics maybe doesn't fit the traditional family dynamics, and there are combinations of names that spouses of the same sex would like to be known after marriage. And so this bill is a practical way to fill what I perceive as a void in the choices of names upon marriage. Thank you.
Thank you, Senator Torres. Signed up to testify on Bill number 158-34 is Mr. Ken Guerrero. Sir, you may begin at any time.
When I first read this bill, I was a bit confused because among my friends, acquaintances, nieces and nephews and siblings, we have people who've kept their surname, adopted the spouse's surname, hyphenated the spouse's surname. So I didn't understand what the point of this bill was, but the clarification being to change the middle name. Is this pretty soon we're going to be able to change our entire name? So say if I were to marry someone, we can both decide that instead of being Mr. and Mrs. Joaquin V. Leon Guerrero, we're going to be Robert and Thelma Bermudez?
No, that's not lawful, and would not be provided.
Well, that's what I'm saying. I didn't understand what the intent of this bill was. And when I first read it, I was against it, but in listening to her explanation, I understand a little bit better. But this goes back to something that we were talking about earlier, about craft and trust and experience, because here we have a situation where we're running deficit operations, our school system is collapsing from within, we have government property being used for private persons, and every single department that we do a drug test on, we're finding scary numbers of employees who are involved in the drug trade. And now we have the governor threatening that our DOC is going to go back into receivership. And we have all these types of problems that are serious, have serious ramifications for the people of Guam. And then we have pieces of legislation like this. Now, initially I was against it. I understand it. I'm just thinking that if we had a part-time legislature, we would be prioritizing the efforts that this body addresses in such a way that we would have a more stable government, and we would see an increasing level of trust. Because when I was preparing for testimony for later, the 33rd legislature did something like 511 bills, 540 or 580 resolutions. In the 34th legislature, we're at 177 bills and 235 resolutions in 8 months. So at this rate, this body is going to be introducing almost 700 bills and nearly 800 or 900 resolutions. But in the meantime, every time we look in the newspaper or see on the news, we see serious problems that are facing this island. And one that I became aware of over the weekend, I took some friends of mine to the Plaza de España. And I was horrified. And then this morning, I'm reading news stories where the city of San Diego is water blasting public areas, the parks and the sidewalks and the benches along the beaches with chlorine, because the homeless people are leaving hepatitis A infections through feces and urinating and their trash in public places. And now this is going to cost the city of San Diego something like $5 million to sterilize the city of San Diego. So I'm just saying that at a time when we have a lot of serious problems, maybe it would be better if we prioritize where we put your time and effort in addressing the things that are catastrophic or serious or have major implications for health, safety, education, which is the charter of this body, to provide for the health, safety, and education of the people of Guam. That is just my point that I would like to make, because when we look at the time and effort that's going into it, and if I were to run through the list of bills that meet this criteria, or the list of resolutions, I mean, I saw a resolution congratulating a woman on 17 years of employment. Are we going to give everybody on Guam a resolution if they meet the 17-year mark? You know, I mean, we gotta, at some point in time, make better use of your time. That's what we voted for you for, to address the problems that are affecting the majority of us. I mean, if you introduce a bill that's going to benefit 5 people, is that really a wise use of your time? Where we have all these major problems that are still not being addressed. That concludes my statement. But for the record, now that she explained it, I understand it better. It's just that in the priority of problems facing Guam, was it really a need?
Thank you, Mr. Leon Guerrero. That concludes the individuals who signed up to testify. Senator Torres, did you have any closing statements?
Thank you for coming around and understanding. And I know that a lot of times we expect earth-shattering legislation, and a lot of times we believe that there should be a priority and certain things should be lined up. But I think in the course of being a legislature, there is a recognition and on my part that outdated laws can be just as harmful as inaction. And anytime that you have an opportunity to update or modernize a law, especially when it corresponds with another prior action, it isn't a waste of time. And unfortunately, you know, by our system, any law, any bill that's introduced, whether it's significant or seemingly insignificant, requires a public hearing. So, you know, this process is part of the democratic process, and we go through it. And I appreciate that you took the time to voice your opinion, even though you thought that it was a waste of time, piece of legislation. But that just demonstrates how important it is to not only pay attention to pieces of legislation, but to act on them. And this is one case where it may not be a big deal, but I tell you, if you're a person whose name is affected, like most women are, your name is a big deal. And being able to carry your father's name is a big deal. So for me, I didn't see any harm in wasting my time in writing this piece of legislation, and I thank you for your support.
Having exhausted the testimony on Bill 158, we'll go ahead and have it considered heard and move on to the next item on the agenda, which is Bill 163-34, introduced by Senator San Agustin. I'll just go ahead and read it, but it's an incredibly long title. An act to modify requirements to become a candidate for office and to make Election Day a Government of Guam holiday, to amend Section 6110, Chapter 6, Title 3, relative to screening candidates in District Court and Guam Department of Revenue and Taxation, Section 5101A and B of Chapter 5, Title 4, relative to prohibiting unclassified and temporary employees of the government from being eligible to be candidates, an amendment to Section 4108 of Chapter 40, Title 5, to increasing village residency requirements for mayors and vice mayors, all of Guam Code annotated and all relative to requirements, eligibility, and prohibition on being a candidate, Also adding a new section 1000A8 to Chapter 10, Title 1, GCA, and to renumber the subsequent sections accordingly relative to making Election Day a Government of Guam holiday. I'll go ahead and yield now to Senator San Agustin for his opening statement.
Thank you, Mr. Chairman. Ladies and gentlemen, I've introduced this bill for the purpose of to right the playing field of candidates, regardless of which party is in the administration is in office, is to ensure that everybody that's running for office not be a GovGuam employee, except for people that are elected. And then moving along on the bill, I've identified the requirement to have a tax clearance. Every candidate that runs for office is required to sign a document, submit the document, part of their packet, that they've been living on Guam for 5 years. I honestly believe that with obtaining a tax clearance, it will indicate and it will show that you, in fact, are a contributing member of Guam, and you are, in fact, a resident, because if you live and work on Guam, you're required to file your taxes on Guam. And moving along on the same bill, I've identified that being a candidate for mayor in the village that you reside, being a resident for only 1 year, I don't believe is adequate. I guess I don't believe you know the village enough that if you live there for 5 years, it's a lot better than 1 year. Because I know folks that have ran and they really didn't know their village. They were talking about the village, but it's only talking about where they live, not about the village itself, such as Dededu, for example, in the previous election. And then the other area that I did identify was the district court clearance. And the only reason why I added that on was because, and I know that there's going to be testimony about convicted felons can't run, understood. But if everybody remembers correctly, in the past, there was an ethics committee that was convened, and it was determined that a sitting senator was in fact convicted of a crime in the mainland. And when you do apply as a candidate for or when you do get your police clearance, the Guam police clearance, it won't show if you committed a crime in the States. When you ask for a Superior Court clearance, it won't show that you committed a crime in the States. But if you ask for a district court clearance, it'll capture everything and anywhere in the mainland. And then finally, I've addressed recognizing that to ensure hopefully maximum amount of participants in the election, that the general election day be a holiday. And I hope for favorable testimony today.
Thank you, Senator San Agustin. Signed up to testify for Bill 163-34, we have Mr. Ken Leon Guerrero, Senator Klitsky, Ms. Maria Pangilinan on behalf of the Guam Election Commission, and the written testimony that they have transmitted. However, she'll be making herself available for any questions. And we have Mr. Victor Cruz representing the Republican Party of Guam. Please join us. Mr. Leon Guerrero, you may begin at any time.
Ken Leon Guerrero with the Guam Citizens for Public Accountability, and I'm here to testify in favor of this bill. Going back to the 2016 election, there were 34 candidates running on both sides. Out of that number of 34, 9 were drawing government of Guam paychecks as as unclassified employees or temporary hire employees. That gave those 9 people an unfair advantage against all the other first-time candidates running for office who had to either resign their positions from government of Guam, and there were several, or had to reach into their own pockets to support their own campaigns. So on that first point, I agree with this bill. I think it will, of course, I'm going to be educated on this. I've talked with Senator Klitsky. He's pointed out some of his concerns. But this is my feeling. The second point is about the additional level of clearances required. I'm in favor of those, especially in light of a number of things that have happened over the past several years as far as government officials who have been, shall we say, on various sides of the line of ethics as far as receiving contracts while in prison and things like that. So I think it's important for taxpayers to know that people who are running for positions where they will be compensated out of public taxes are at least paying their share of taxes. I like the idea of the district court clearances because as our population becomes more transient, as we have more people from Guam returning from 20 and 30-year sojourns to the mainland like myself. I was gone for 28 years, and I know that a large number of people in my age group are returning back to Guam looking to give into the community, and it would be nice to know that we are able to capture any felony convictions that had taken place outside of this jurisdiction. The residency requirements for mayor I wholeheartedly agree with, because people were trying to get me to move to a village to run for mayor. So I didn't think that that was appropriate, and I didn't do it, but I'm sure that there are people who would be willing to do such a thing, because we see this problem happening in the mainland all the time with people moving into districts just to get elected. I think that in view of the work that mayors perform, it is better that the mayor has some knowledge of the community beyond where it is on a map. That concludes my testimony in favor of Bill 163.
Thank you, Mr. Longuerro. Senator Klitsky.
Thank you, Mr. Chairman. I just add, as an aside, I wish that Senator Torres's bill had been the law over 50 years ago, because then I could have taken the name Palomo instead of being stuck with the unpronounceable mouthful that I have now. But my name is Robert Klitsky, and I'm here to testify in favor of Bill 163, but I'm also going to testify in opposition to it after I finish testifying in favor of it. In favor of it, Honorable Senator Mike St. Nicolas and members of the Committee, General Governmental Operations, etc., the policy expressed in Section 1 of the bill is indeed salutary and deserves your support. And I pick out one section there. It is not desirable to have certain unclassified and temporary employees retaining their salaries and positions with the government and at the same time running for elected office. I likewise support the noble policy initiative that is attempted in Section 3. The intent of the bill, the intent set out in this bill would have a dramatic effect on this body by ending the political oligarchies that are attempted by each successive administration. The timing is right to level the playing field, as your current majority and the outgoing administration are not of the same party. Unfortunately, my support ends there. 163 is actually 4 bills with one number. The salary bill, that is Section 3, is burdened with unconstitutional provisions that should prevent it from ever getting off the ground. I support the intent of Section 3 and have offered my humble suggestions to correct the problems in Bill 163 under separate cover. My apologies for belaboring this committee with apparently conflicting testimonies, but the current reckoning of what can constitute germane provisions in a bill, coupled with your sign-in procedure, leave me no choice. You either got to sign for or against. So that's my testimony in favor of the bill. Now I will testify against the bill. There is no effective prohibition for any government of Guam employee, classified or unclassified, to run for senator, lieutenant governor, or governor. I'm going to repeat that. There's no effective prohibition for any GovGuam employee, classified or unclassified, to run for senator. As explained below, this body is powerless to change the eligibility requirements for these offices. But before we delve into that, congratulations are in order. Senators, congratulations. You are members of the only organic branch of our government which has the highest standards for election thereto. No criminals allowed. All four of the elected offices created by the Organic Act have requirements as to age, citizenship, and residence. But the Organic Act bars felons from service in this august body alone. The Organic Act language creating the other officers, governor, lieutenant governor, and delegate, does not bar felons from serving. With respect to your office, however, the Organic Act is clear. No person shall sit in the legislature who has been convicted of a felony or of a crime involving moral turpitude and has not received a pardon. So the political destiny of those unfortunate folks who have been convicted of felonies or of crimes involving moral turpitude lies only in candidacy for this body. I suspect there's nobody here that remembers a gentleman named Phil Gutierrez who wanted to run for senator, but his application to run for senator was rejected because he had been convicted of a felony. So he said, fine, I'll run for governor. And he filed his papers and ran for governor. He didn't win, but he proved a point. Legislative attempts, including this bill, to fix the problem don't pass constitutional, or in our case, Organic Act muster. The U.S. Supreme Court has held that constitutional requirements for office cannot be modified by statute. Now, I have read General Rapanis' opinion about the efficacy or the inability to go beyond stated requirements or stated eligibility requirements in state constitutions, and that there are some that go the opposite way. But we're not dealing here with a state constitution. We're dealing with the Organic Act, which is located at 48 United States Code, Section 1421 and following sections. So a court, in looking at our Organic Act, which is, like it or not, a federal statute, is going to pay an awful lot of attention to the Supreme Court's, U.S. Supreme Court's decision in Powell versus McCormick, which is pretty clear. So I've sent out a quote from Chief Justice Earl Warren, who's still not one of my favorites, and also the concurring opinion by Justice Douglas. The quote hasn't changed since I testified a few minutes ago, so in the interest of brevity, I won't read it again. Let's see here. As egregious as the perceived omissions from the Organic Act may be, they are not curable by legislation. For this reason, several well-intended provisions of the bill should not be enacted. Now, I do suggest a fix, and I do want to stop here and point out I'm not talking about mayors, public auditors, attorneys general, vice mayors, only the four Organic Act offices: the governor, lieutenant governor, senator, and Washington delegate. So Section 6110 could be fixed if you just accepted out the governor, lieutenant delegate, and senator. There's a typo there, but yeah, if you just took those out of the bill, it would stand as far as the other offices are concerned. Section 3 has a noble policy objective. That is that no GovGuam employee should run for elective office while on the government payroll. In order to achieve this noble objective, work on the laws speaking to government employment rather than laws governing eligibility for candidacy must be addressed. Chief Justice Earl Warren above said Congress is limited to the standing qualifications prescribed in the Constitution. Same goes for our legislature and the Organic Act. So simply put, you can condition continued government employment on not being a candidate, but you cannot condition being a candidate on not being a government employee. Now there's a tongue twister for you. But you can have a statute that says if you become a candidate, you're fired. But you can't have a statute consistent with the Organic Act says that all you government employees can't run for senator. The name that pops up here in my memory is Ben Palomo, because there was a statute on the books at one time that attempted to do exactly what this bill did, and Ben Palomo was a candidate. I don't remember if it was a court case, Attorney General's opinion, or whatever, but Ben Palomo did get to run. Didn't win, but he got to run. Tinkering with the election ability provisions in Title III won't do it. Clearances from the police, the courts, and taxation authorities cannot serve as a bar to candidacy. As above, eligibility requirements are established by the Organic Act only. And I mentioned in a footnote there the matter of clearances. As far as tax clearance are concerned, you got to have a tax clearance to renew your business license. I suppose all of you Guam tax mavens are very familiar with those provisions, but absent that tax clearance, you can't get a business license. And even if you owe taxes, you can make a deal. The Director of Revenue and Taxation will play let's make a deal with you, and if you make a deal, then you can get a tax clearance and you can get a business license. Now, I've probably been as long as I should be this morning, and so I'm not going to go any farther than that, but think in terms of business license and running for the legislature. It's not a good mix, but consider the possibility or consider the wisdom of that Organic Act section or the law dealing with eligibility for candidacy. Let's say that a would-be candidate did have a tax liability, and he went to the Department of Revenue and Taxation, went to the director and said, no, I'm not going to work out a deal with you. You can't have a tax clearance, for instance, because I don't want you to run for senator. And the guy is out of luck. So that provision won't go as far as those 4 constitutional officers are concerned. One of the objectives of the bill is, quote, prohibiting certain employees from running for office. The remedy is not found in Title III, elections, but Title IV, political activity. Political activity by government employees is governed by 4 GCA titled political activity. And note well that provisions defining candidacy are set out in Title III, elections. Under current law, employees, with 2 exceptions, are prohibited from political candidacy at the risk of punitive discipline concerning their employment. The disciplinary tribunal is the Civil Service Commission. The discipline is to be imposed, and the criteria for imposition are so lacking in standards as to be held void for vagueness. Here's the law. When any person has reason to believe that an employee has violated Section 5103, he may report the matter to the Civil Service Commission. On receipt of a written report which seems to the Commission to warrant investigation, the Commission may investigate the matter. Commission holds a hearing, and then down at B, the decision of the Commission shall include a determination of whether a violation of Section 5103 has occurred and whether a violation warrants the removal of the employee from his employment. Should the Commission determine that the removal is not warranted, but that a violation of Section 5103 did occur, a penalty of not more than 30 days suspension without pay shall be imposed by the Commission. So, as you can see, the law is doffy. And if an employee is decided to be a candidate, he could give it a try with little risk to the employee. There would be no consequence to the employee unless four things happen. One, someone filed a complaint. And the Commission can't act sua sponte, that is on its own, nor can the Election Commission, because the statute says, the statute limits complainants to natural persons. Check the language. When a person, he, etc. So first of all, somebody has to file a written complaint. Second, the complaint seemed to the Commission to warrant an investigation. Now, I just don't know how to deal with the word seem. The Commission sits around and deliberates and says, well, it seems like there's a violation. And somebody, oh no, it doesn't seem like it to me there's a violation. It just seems to be a rather dull tool by which to use in making important decisions. Okay, so if the complaint seemed to warrant an investigation, the Commission has to determine that a violation occurs, and then the Commission determines that either a termination or a suspension of up to 30 days is warranted, or no suspension at all. So somebody, and this is classified or unclassified, so a classified employee could file his papers for senator and hope that nobody filed a complaint. And he keeps working, he keeps drawing his pay. It's not beyond the realm of possibility that no one filed a complaint because, well, you know, I didn't want to because I didn't want I just didn't want to do it. So then somebody files a complaint, and then we go through the whole, whether or not it seems that there's a violation, etc. So even if it worked, it would take quite a while. So if the would-be candidate timed his filing, it may take the Civil Service Commission so long to even get down to the point where they determine whether it seems like there's a violation that the guy could be elected. It is possible that a classified employee could run for senator and win, lose, or draw, not be disciplined. Or a classified employee could run for senator and win, thereby mooting out the potential discipline. Not only is the disciplinary mechanism ineffective, it is fatally flawed. No standards govern the decision-making process of the Civil Service Commission. When the Commission evaluates a written report which seems to the Commission to warrant an investigation, the word seems to call forth nothing more than the gut reactions of the commissioners. There's no standards. The Commission determines that either termination or a suspension of up to 30 days is warranted, or maybe no suspension at all. Based on what? Again, no standards govern the Commission, making it very possible that one employee could run for senator and not be punished, while another employee could be fired for the same conduct. And of course, there is the possibility that no one would file a written report with the Commission. If it is desired that government employees not be candidates for elective office, then in NIFEN, something like this is recommended. And I've set out 4 GCA section 105B and suggested the addition of a proviso at the end that would read, provided, however, that the finding of the Commission of a violation of section 5103B4 shall result excuse me, in the termination of the employment of the employee effective the date of the beginning of the violation. Probably a lot of other ways of going about it, but that's the only way that you can achieve the very noble objective of this bill, Senator San Augustine, is by working at it from the employment end of the spectrum. Heroic attempts at screening candidates for the 4 organic offices won't work, nor will adding requirements to those found in the Organic Act. In its current form, I have no choice but to voice vehement opposition to Bill 163. Thank you, Mr. Chairman.
Thank you, Senator Clissy. So just to clarify, you've submitted testimony that is 2 pages in support and 7 pages in opposition, so you are 28% in support of the bill.
You could reach that conclusion, Mr. Chairman, yeah.
Just for the record. Thank you, Senator Klitsky. Mr. Cruz.
Affidavit, Mr. Chairman, and members of the committee. My name is Victor Cruz, and I'm the chairman of the Republican Party of Guam. I'm here to register the Republican Party's testimony against this bill, Bill 163. The Republican Party continues to be puzzled by election bills that have been coming out of this legislature. The most recent one is troubling as the limit of choices that the voters have for this upcoming election. When the legislature voted to cut their salary this year and reduce below the national average, it actually also affected people that are intending to run for the legislature. When the legislature proposed Bill 163, it again will limit the amount of people who can run. It tells voters, senators are smarter than them, and they're better, and they should know who to run. The outcome of this policy, such as this, is that our voters would have less choice in the next election, and our island will be limited to the range of qualified leaders who can run for office. If this bill were public law 4 decades ago, it would have changed the outcome of Guam history as we know it, as elected officials such as former Senator Rory Spicio, Senator Tina Muna Barnes, former Senator J.Q. Kanata, former Senator Sasaki, former Senator Joanne Brown, former Senator Tony Palomo, and the late Senator Tony Blas, and many other successful policymakers who might not have been elected leaders, as the law would have forbid them from running from this cabinet. The Republican Party is committed to reminding the public of the negative impact of this bill will have on their choices of this upcoming election if the unclassified provision is not withdrawn. I also want to say that after going through this bill, that it basically exempted the legislative branch employees at the same time. Thank you very much. That's all my testimony.
Thank you, Mr. Cruz. I think we also have Senator Morrison, Senator Muña, and Senator Castro also, right? Yeah. Who fall within that same category.
And you also had, I don't know, but you also had a legislative employee that ran, Jermaine.
Yes, yes.
And I didn't know if he resigned or not.
Yeah, no. We have
okay.
So there is a history of people running for, yeah.
Okay.
My only question that I wanted to bring up was, you know, and this is in line of kind of like the conversation I'm having with Mr. Cruz, but what was also shared by Senator Klitsky is, you know, with the Civil Service Commission, the intent was to provide greater protection for the classified service, to give them a due process for protection. But now, I think that's like, this is like one of the unique examples where employees in the classified service would actually have the Civil Service Commission being used to penalize them for running for office, as opposed to unclassified employees who would not have any Because you could not go to the Civil Service Commission to seek a penalty against an unclassified employee. Am I incorrect there, or is that a correct assumption?
Sort of. So the Civil Service Commission is a tribunal. The tribunal tries, in a sense, tries disciplinary appeals. That's its major function. When we decided that we wanted to have our own Hatch Act here, that Hatch Act, which everybody refers to as the Mini Hatch Act, was assigned to probably the only tribunal available at the time, which was the Civil Service Commission. So the Civil Service Commission is supposed to adjudicate matters involving that chapter on political activity and determine if the employee had violated one of the prohibitions dealing with political activity. Up until just a short time ago, it was one strike and you're out. If you violated the law, you were fired. If you were engaged in impermissible political activity on the job, you were fired. In the process of trying to make it more fair, they basically took all the air out of it so that it is now basically a dead letter. So if we are to discipline employees for political activity, impermissible political activity, like being candidates, and the Civil Service Commission doesn't fill the bill, then we have to have another tribunal, and that's not easy. Civil Service Commission has, I think it also sits as the appellate arm of the whistleblower protection part of the government. And although it was removed at one time, they now also serve not only as a tribunal, but an inquisitorial function under what they refer to as their post-audit authority, where if they think something went wrong in the government, they can go forward and set aside a personnel action. That, to me, is also as in Congress as having the political activities tribunal duties cast before them. Unfortunately, I don't see an easy way of fixing the political activities matter. I don't think you want to create a whole new tribunal just to try the occasional political activities violation. I can't speak for the chairman of the Election Commission, and I can't read her mind either, but I suspect that probably that's something that the Election Commission wouldn't look forward to either. However, it probably fits better there than it does in the Civil Service Commission. But as it is, it's almost like having no tribunal at all for the reasons that I mentioned, so that any bus driver that felt like running for senator, as far as I can tell, especially if you had a good lawyer, could do it, and there wouldn't be much of anything happening to him. Thank you, Mr.
On that note, Ms. Pangilinan, if a classified employee wanted to run for public office, would the commission or its administrative functions at any time prevent them from filing for candidacy and putting their name on the ballot?
When questions come up, sir, we refer them to the Civil Service Commission. If somebody would come and say, I'm a classified employee and I want to run for office, we would refer them to Civil Service Commission, and if they still intend on running, we go ahead and give them the packet. Because they would have to sign certification of qualification that says they are qualified to run.
Is part of that certification of qualification that they are not a classified employee? No. Okay. So when you say you would refer them to the Civil Service Commission, what exactly does that mean? Would you tell them to go and get clearance?
No.
Okay.
No. On the Civil Service Commission website actually has the little pamphlet a little guide that says what you can do and what you cannot do as a government of Guam employee.
So basically then the only prohibition we have for classified employees running is the fact that, not that they cannot run, but that if they did, they would potentially be subject to termination if these proceedings were were to take place?
Outside the parameter of the Civil Service outside the parameter of the Guam Election Commission, unless a complaint is filed with us.
So just to be clear for the record, classified employees would have no problem picking up a packet and running for public office?
They won't have a problem picking up a packet, yes, sir.
Okay. This is very interesting dialogue, very interesting conversation. Mr. Cruz.
I think just based on what the executive director of the Guam Election Commission said, on my part, as a private citizen, I think they should allow classified employees to run also. Not just the unclassified, but also pick, because, you know, you're giving the people of Guam the choices of candidate. The way I see it is that at times when the election commission, when the election is just rolling around, both parties, my counterpart on the Democrat has even said, man, Vega, it's hard to get candidates. And sometimes the candidates that comes and talk to you and run, you know, you just have to smile at them and say, well, give it a run, you know, because that's why, as I've mentioned before, I feel that the registered political party, the Republican Party and the Democratic Party, should be allowed to conduct their own primaries. You know, it would not only save the government, but you know, that way, the party himself, officials can say, okay, yes, you can run. I'm sorry, but you can't run.
Did any of my other colleagues have any questions for the panel? Senator
Yes.
Sinagist.
Ms. Pangilinan, you mentioned that any classified employee can pick it up a packet. I think that's very easy to be understood. But at the same token, when I picked up a packet and I was referred to the commission, I was referred to the Mini Hatch Act that specifically states if you're a GovGuam employee, you have no business running for office. And I've always was told at my employer that, Joe, if you're running, you have to resign or you're subject to termination. Okay? That was very clear. That's why everybody that ran for office that were a classified employee resigned. And all this bill is to level the playing field. Now, regardless of which party's in office down in Adelup, when it was the Democrats, there was a bunch of them unclassified running. Now that it's the Republicans, there's a bunch of them running. All this is asking for is to level the playing field, regardless who's in office. And I think you asked Mr. Cruz about, is there exemption from the legislature if somebody's unclassified here? This would include everybody, regardless of where you work, if you're unclassified. And on the area that Senator Klitzky brought up about the tax returns, if we take a look at one of your testimony you presented, you identified the criteria to run for office as, I think you used Justice Douglas, that 25 years old, U.S. citizen, 5 years domicile in Guam, no felonies or moral turpitude misdemeanors. Not a problem. The only thing I added here was, if you're 5 years domicile in Guam, to support that letter that every candidate submits that we signed saying we lived on Guam for 5 years, not necessarily, maybe the word tax return should be maybe a certification that you filed taxes on Guam, that's all. Not a clearance, something to say that you have filed on Guam, you worked on Guam. Because at the same token, if the individual that's running for office hasn't worked for 5 years, they'll never get a certification. They would have to figure out a way how to prove that. And the only reason I bring that up was because at the Election Commission, all you get is a letter you sign that I lived on Guam for 5 years and have a nice day. And I hope nobody can prove that I didn't live on Guam. The next part there, no felonies or moral turpitude. Misdemeanors. The only reason why I added the district court is just to basically validate that you have no felony conviction or misdemeanor conviction or moral turpitude, nothing more. And I think that was a very simple, but I can understand where you're coming from, Senator Klitzky.
Senator, on your point about residency and everything, so what do you do for a veteran who served his country and lists Guam as his home of record, and spend 20 years away, then come back and decide to make Guam home, and is here for 2 years and decide to run. Is he exempted from that?
The Mr. Cruz, when you talk about a veteran, somebody served his country,
Somebody that serves his country, retired all of it, making Guam his home of record, and come to Guam and live.
you need to understand when you say home of record in the military, Mr. Cruz, that's normally referring to tax purposes. Now, when you talk about home of record, when the military sends your record, when you retire, it sends the record to Guam, your DD-214, for purposes of the election, and I read it, 5 years domicile in Guam. If you came back 2 years, you're still short.
Okay.
So it doesn't matter. I mean, I'm a veteran, I'm retired.
Yeah, I understand.
And every retiree understands that.
Yeah,
So
understand.
5 years, that's all I was adding on.
Point of interest also is that on Section 3, when you mention employee, I don't see the legislative branch.
I beg your pardon?
On your bill, on Section 3A,
Oh, I can see where you come from. Then we'll add the legislature branch.
okay.
I apologize for that. Didn't notice that. Thank you for catching that.
I wanted to address the matter of the tax clearance that you raised. There's no requirement that anyone ever have a job in order to run for the legislature. So if one of these gentlemen that we see perhaps out in front right now felt like running for the legislature, he wouldn't have any ability to get a tax clearance because he's never worked and he's never paid taxes. But the very nature of elected office is such that he could not be barred on that basis. So my curbstone opinion is this: in order to perfect a candidacy, you could require that a person swear that he's never been convicted of a felony in any jurisdiction anywhere in the solar system, or that he's never been convicted of a crime involving moral turpitude. You could have him swear under penalty of perjury, and if you really want to make it tough, increase the penalties, the punishment for filing a false affidavit to support a candidacy. But once you start involving third parties in the process of perfecting an eligibility, whether it's the Director of Revenue and Taxation or the clerk at the district court or whatever, then I think you've run right smack into Justice Douglas, who says all you can do is what's in the Constitution. You can't involve third parties. That would be my curbstone opinion on that one, Senator.
Senator Vice Speaker Talai.
Thank you. First of all, I want to apologize for being late. And the speaker's off island, so I was summoned to the district court. But my staff has been texting me what your testimony was that I missed, and I heard most of yours. And I just want to confirm, if Guam Election Commission, you require a sworn statement, and you said that it includes that we have to swear we are not a classified employee right now?
Not correct, ma'am.
Oh.
That's not included in the certification of qualification.
Oh, it's not included?
No, it's not
I thought
included.
you said it was. Okay. All right, and I know the statute used to read that unclassified employees were prohibited, is that right? And the Election Commission, there was a case when I was on the Election Commission, if my memory serves me right, it was Senator Palomo who challenged that and won the case. Yes, did you say that earlier? And yeah, he won that case and, pardon?
Some of the testimony included that matter, Senator.
Okay. Yeah. Maybe on the other bills. Yeah, so I was just wondering if you have that court case, the decision. I remember that was commonly something that the Election Commission had to bring up again and again when the unclassified employees were one.
The rule at that time was that that government employees couldn't run for office. Ben Palomo was the director of public works. He wanted to run for office. I don't remember the exact mechanics of it, but the election commission said pretty much what I said in my testimony here. You can restrict employment, but you can't restrict candidacy based on employment. So he ran, but he didn't win.
That's correct. I'm just asking the election commission if you could pull up that court case and send it to us. I would appreciate that. I know you have it in your files because it was there.
We will.
All right, and Senator Klitzky, I know you said you object, I just want to make sure, to the last section of the bill regarding the holiday?
Yeah, I do, yeah.
Yes, opposed to the fourth bill makes Election Day a holiday.
That's about 2% of my objection, but go on.
Did you, can I just ask, did you testify earlier why, or can I ask you why?
Well, the polls open at what, 7 in the morning, and they're open till 8 o'clock at night. There is every person on the island is entitled to a 2-hour break from his employment. People that want to vote, I think, can vote. People who want to participate in the all-day long barbecues can take leave. But my calculation is that it costs us about $400,000 to shut the government down in direct costs, and perhaps as much money in indirect costs for all of the things that people want to do and can't do when the government is shut down. So we have a fair number of government holidays now. Senator Ompinko, may he rest in peace, reformed our whole holiday setup, got it back down to what I thought was a reasonable number, but we gradually crept back to where we were before that, and I see this as just one more small step back in that direction for a purpose that I think is perhaps doubtful at best. There are ways that people can vote early if they have good reason to not be able to come to the polls on time, etc. So, but as I mentioned, that's only one of the 4 bills under that same number, and I directed all of my testimony to Section 3.
The other provision, yes, correct. And Mr. Longuerro, did you testify that you were in support of this provision of the bill?
I didn't testify, but I am now. I initially wasn't until I started talking to people I know that didn't vote and asked them the reasons why. And most of the people that I talked to that didn't vote were single moms or young families. And the logistics of getting kids to school and then getting to work and then trying to get from Jigo down to Dedido to vote in 2 hours and get back, and then picking up kids after school and dealing with the after school activities kind of pulled me in that direction, because I was against the holiday at first just because of what Mr. Klitzky talked about regarding the cost. But one of my goals as a community advocate has been to get more people to vote, to get more people to the polls. Now, if it had just been 1 or 2 or 3 people, then I would have kept my previous position. But almost every single mom I talked to that works for government of Guam voiced that concern. So I figured, okay, if about 10 or 15 people all fit the same profile, then maybe there is something to it, and that's why.
All right.
You know, I have been looking at alternative ways of voting, and in my testimony on Bill 45, I pushed several other ways of early voting, voting by mail, and other things that are gaining popularity in the States, and Bob and I will arm wrestle over these later.
Thank you.
As a way of getting more people to vote.
Right. All right, and Ms. Pangilinan, can you tell us, do you have data that shows the effect of a holiday versus not holiday on the percentage of people that actually make it out to vote?
We can put that together from our election comparative analysis reports. We have voter participation, and we'll just have to go back and say and check when it was a holiday and when it wasn't.
I'd appreciate that, please. Thank you.
Any other questions from any of my colleagues? If not, Senator San Agustin, would you like to make a closing statement on the bill?
Thank you, Mr. Chairman. I'd like to thank the the support and non-support. Just the participation is really, I really appreciate it because it's good input, and I will take a look at the bill and see how we can fix it. I will be calling you, Senator Krisky, because I would seriously like to take a look at that issue on the personnel rules and regulation that governs that, and that's the best way to fix it, and that's the right way to fix it, then so be it. But I do take all the testimony to heart. Thank you, Mr. Cruz, Ms. Pangilinan. I like your testimony here, and Mr. Leongro. Thank you, ladies and gentlemen.
Thank you, Senator San Agustin. Just for the record, Senator, the committee will work with you closely to determine how you want to move forward. We may want, on advisement from the testimony, we may want to consider perhaps segmenting these things out and approaching them separately. We'll communicate with your office to determine your most desired course of action. That being said, I'd like to thank this panel for spending the whole morning with us and for your testimony here today. We'll go ahead and consider Bill number 163-34 as having been heard, and that will exhaust all of the items that we have on today's agenda. Thank you all very much for joining us. We will adjourn at 1 o'clock this afternoon. Thank you very much.